to start out, I'd love to learn just a little bit of your background, sort of the work you've done throughout the federal government before you got to the EEOC and in the work there for the past several years.
Sure. No, and thanks so much for wanting to chat with me. It's a pleasure to be here. I have spent the last 35 years or so moving between civil rights enforcement agencies in the government and outside public interest groups that advocate for equity of different sorts. I actually got my start at the EEOC as a career civil servant back in the 1990s. Left for a while to work for Ted Kennedy on the labor policy component of the HELP committee, went to the National Women's Law Center, then was in the Obama administration at both the Justice Department and the Department of Health and Human Services. Left during the first Trump administration and then was lucky enough to be nominated by President Trump in 2020 to come back to the EEOC as a commissioner, and was confirmed by a bipartisan vote of the Senate in September of 2020 to come back, and stayed at the commission until I was terminated on January 27th, 2025. So I just have felt exceptionally lucky to be able to spend a career devoted to civil rights, particularly in employment, and trying to ensure that vulnerable people can get truly equal opportunity in the workplace and elsewhere. So it's been a real privilege to do this work.
Absolutely. I think a lot of Americans might not necessarily know what the EEOC is or what it does. So in layman's terms, what does it do?
So in the alphabet soup of Washington, the EEOC is the Equal Employment Opportunity Commission. It is the primary federal agency that enforces the laws that bar discrimination in employment based on race, color, national origin, sex, religion, disability, age, and genetic information. EEOC has a plethora of tools to do that work. A lot of them are front-end tools to help people understand their rights and employers understand their responsibilities, because the ethos of the EEOC, and in fact the requirement of the statute that created it, is to pursue voluntary compliance as the preferred means of enforcing the law. So the EEOC puts out regulations, guidance documents, fact sheets, technical assistance. I spent a lot of time when I was on the commission doing public education and outreach, talking to different groups of stakeholders to make sure they understood what the law required and what their processes would be if they felt that they had been subject to discrimination. EEOC also has the authority to address things at the back end. And so anybody who feels that they have been subject to prohibited discrimination is required to come to the EEOC or one of its state counterparts to file what's called a charge of discrimination. They don't need a lawyer to do that. The EEOC investigates it, offers multiple opportunities for the parties to voluntarily resolve the issues that divide them, and ultimately makes a determination about whether discrimination has occurred. If it finds that there has been discrimination, it also has the authority to take employers to court and to challenge the conduct and attempt to get remedies on behalf of the individuals who have been harmed. So I think the EEOC is both a required first step in the process for people who want to vindicate their rights, but also an invaluable source of information and guidance, particularly for employers who in good faith want to follow the law and want to understand what it is. But it can also use its enforcement tools to pursue remedies and vindicate the rights of people who it finds have been subject to discrimination.
That's so helpful, and I want to get into sort of both of those sides. But before we do, your firing and some of your colleagues has meant that the commission does not have a quorum right now. So what type of work is and is not allowed to happen in the current situation?
So because the commission lacks a quorum is 3 members, there are currently only 2. The commission can do no business that requires a commission vote. whether that is the issuance or amendment of regulations, the issuance of significant policy guidance, the determination to litigate particular kinds of cases that have to come to the Commission for a vote, decisions about claims filed by federal sector employees, which come to the Commission for appellate adjudication and are subject to Commission votes in some circumstances. All of that work is completely on hold. In addition, I think because the resources of the Commission have been diminishing over time, and the administration's determination to slash the budgets for civil rights enforcement agencies will have effects, even those functions that can continue despite the fact that the Commission lacks a quorum are understaffed and under-resourced and will take longer and mean less immediate ability to vindicate the rights of people subject to discrimination and provide the kind of guidance that employers value and expect.
How much or sort of what type of engagement would the average American expect to have with the EEOC? You know, I can envision some of the viewers of this saying, oh, well, that's for big companies that are doing terrible things, but it doesn't really bother me or matter to me. What's your thoughts on that?
So the laws that the EEOC enforces cover any employer with 15 or more employees. With regard to age discrimination, it's 20 or more employees. But that's a huge swath of the workforce that is covered by the anti-discrimination laws and should be aware that they have rights to be free of discrimination, whether it is with regard to losing a promotion on the basis of race or sex or disability or another prohibited classification, being paid less than their coworkers who are doing the same work, being riffed or fired on a prohibited ground, being subject to harassment in the workplace, which the Supreme Court has made clear is a form of discrimination because it affects the terms and conditions under which people are required to work. These are issues that arise every day in the workforce. And the thing that people should be aware of is that these anti-discrimination laws are broad and cover every aspect of the employment relationship. And if they feel that they are subject to discrimination, they have a mechanism to address that discrimination without hiring a lawyer, without it costing them any money. This is a tremendous service to people who are subject to discrimination. And for the thousands, hundreds of thousands of employers across the country, it is also an incredibly valuable resource to make sure that they can stay on the right side of the law and address problems at the front end before they result in liability at the back end.
So to that end, obviously this administration has a very different approach to civil rights, diversity, equity, and inclusion, those sorts of issues than past administrations. And the new acting chair of the EEOC has put out guidance essentially saying that such diversity in hiring initiatives, DEI programs, might run afoul of federal law. How confident should Americans who feel like they might be experiencing discrimination in the workforce feel about their ability to pursue, legal recourse or recourse through the EEOC, given the current situation?
So the EEOC is required by statute to investigate every complaint that is filed with it. That is not a discretionary responsibility. That is something that the statute requires them to do. The EEOC is staffed by career civil servants, many of whom have been with the agency for decades, and I think with tremendous integrity and competence apply the law to the facts that are presented to them and try to render decisions about whether discrimination has occurred without any kind of political overview about what this will mean. As I mentioned, employees are obligated to come through the EEOC before they can go to court. So at a minimum, people should file complaints with the EEOC and can then request what's called a right to sue letter, which is a document that says, yes, they've checked this box, they have gone through the EEOC process, they now are authorized to go to court. And then if they choose to, they can file their own lawsuits to challenge their employers in federal court in whatever state they're located.
You mentioned sort of the lack of resources the EEOC had even before sort of what DOJ has been doing across the federal government. And because of that, a number of sort of experts and business leaders I've spoken to have spoken about how the EEOC's rulemaking and education sort of, and their enforcement actions serve as a sort of warning to employers that don't engage in bad behavior because we could come after you, with the understanding that the EEOC does not have the resources to pursue every such claim and that sort of thing. I'm curious if you're concerned at all about any sort of reverse chilling effect, or might employers feel more emboldened now to engage in illegal behaviors because of the messages they're hearing from the EEOC that, you know, it appears DEI, diversity initiatives, those sorts of things are no longer important?
You know, I really hope that that is not the case. And my firm belief is that the vast majority of employers want to comply with the law. They just want to know what the law is. And one of the concerns that I have is that both the resource constraints and the political leanings of this administration will undermine the breadth and the helpfulness of the guidance that the agency issues. But look, resources are a real problem. I think that has been true for a very long time. When I worked for the EEOC in the 90s, there were about 3,200 employees across the agency. When I came back in 2020, it was down below 2,000, and I think when I left, it was somewhere around 2,200. I'm not sure of the precise numbers, although those are publicly available. People can find out. That is not adequate staff to do the kind of, or resources to do the kind of job that the American people deserve in terms of enforcement of these fundamental rights to have equality of employment opportunity. So I am very worried about that, have been for years, and even more so as there are threats to further cut what the EEOC can do. That said, I do think that, again, because the EEOC is statutorily required to investigate every complaint, they won't be able to get to it as quickly as might be ideal, but employers are not going to be off the hook because individuals can come forward to protest the discrimination to which they've been subject, whether the EEOC has a full complement of resources to move their complaints forward expeditiously or not.
The central argument the Trump administration appears to be making in the executive orders the president has signed about DEI and the guidance that EEOC has issued and others is that non-minority, particularly men, have been discriminated against, that they are not getting a fair shot because of all of these types of DEI initiatives and anti-discrimination laws. Are you aware of any evidence that white men, straight white men, are being discriminated against in the workplace?
You know, I think if they are, then that is something the EEOC should investigate and address. But in reality, I think that what the volume of complaints that the EEOC has gotten, what the literature demonstrates, and what people's everyday experiences show is that there is far, far too much discrimination still against people of color, against women, against people with disabilities, and that is the product of pervasive systemic inequities that have not been addressed by our country. I think the president's attacks on DEI initiatives are heartbreaking and particularly a disservice to vulnerable communities because properly understood, DEI work is simply a proactive set of efforts by employers to identify and address barriers that are limiting people's employment opportunities before they result in some legally justiciable discrimination, and to send the message that these kinds of actions, which I think are both lawful and critical for advancing true equality of opportunity, are somehow inherently discriminatory, is, I think, this sentence was obviously went around and around and around.
Not at all.
It is a disservice disservice to employers and the people they employ to suggest that employers cannot take the kinds of proactive steps that the law itself anticipates they will take in order to proactively identify barriers and address them before they exclude people from employment opportunities. I think employers absolutely need to be very intentional about their DEI work and evaluate the programs that they are offering to make sure both that they are lawful and accord with long-standing legal standards and that they're effective in serving the employer's goals. But to suggest that an employer cannot do things like data collection to see whether it has pockets of underrepresentation, or broad-based recruitment to make sure that it's not excluding sources of qualified candidates, or climate surveys of its workplace to find out what kinds of concerns its employees have, to suggest that those are inherently discriminatory steps that will get employers into legal trouble is both inaccurate as a matter of law and I think stands to really undermine the kind of equality of employment opportunity that the EEOC is supposed to support.
Last sort of question on that topic. You've mentioned what statute requires of the EEOC. They have to investigate every complaint, but there's no denying that the public statements from this administration, from the new EEOC leadership, certainly calls into question how committed they are to some of these concerns about anti-discrimination laws, those sorts of things. What's your message to a worker or an employer who might just be worried that any claim they make, any sort of information they share is going to be brushed off as being woke and won't be pursued?
I understand that concern, and I am deeply troubled by some of the public statements that the acting chair has made, and certainly that the administration as a whole has communicated through the president's executive orders, for example, on DEI, or the notion that sex is a binary, immutable, biologically set characteristic that cannot be changed. Those are assaults on fundamental rights that people have to be who they are and to enjoy equality of opportunity across a host of areas. But that said, again, EEOC career staff are supposed to investigate the complaints that are filed based on the facts presented and the standards of the law. And while EEOC has regulations and guidance that state its view of what the law is, ultimately it is up to courts to make that determination. And anybody who goes to EEOC to file a complaint but wants ultimately to litigate it in court has the right to do so. It has to give the EEOC an opportunity, the person has to give the EEOC an opportunity to investigate their complaint, but they can request a right to sue letter and go into court if they feel like a court will give them a fairer hearing than they think they have received at the agency.
You brought up the acting chair, who you worked with for some years while you were on the commission. What was your relationship like? What's your perception of her?
You know, I really believe in bipartisanship as the gold standard for policy making. And I think the acting chair and I, while I was there, really tried to model a principled approach to making decisions about the interpretations and the policy positions that the EEOC ought to take. We had regular meetings where we discussed our views about different matters that were pending before the agency. They were always respectful and collegial, and I think we were really inclined to listen to each other. There were absolutely areas where we were far apart in our interpretation of the law and in our views about the policy that the U.S. government should pursue. But we were engaged in respectful bipartisan dialogue. In fact, on one occasion, she asked if I would appear on a Federalist Society panel with her, which I did. And if your viewers don't know, the Federalist Society is a nonprofit think tank type of organization that has nurtured conservatives over the course of the last 3 decades or so, and is kind of a seedbed for development of conservative ideology. So I thought, okay, there's no one I can't talk to. I want to hear what they have to say so that I can consider it and help to refine my own thinking. So I would say that during the time that I was there, although I was disappointed by some of the positions that she took and her unwillingness to vote for certain things that the commission put out, like the Pregnant Workers Fairness Act regulations or the harassment guidance, I nonetheless thought that we were excellent colleagues, which is why the public statements and actions that she has undertaken since the president's inauguration have been really deeply disappointing to me, because I think they reflect a politicized ideology that is dogmatic and does not encourage a discussion of differing views and an openness to considering viewpoints that don't accord with her own.
Have you had any communication with her since your firing?
I have not.
Speaking of some of those actions she's taken, I just want to talk through some of them and hear both your perspective on the, sort of the impact, the outcomes of them, but also whether these align with sort of previous actions that EEOC has taken, regardless of their, political ideology. Sending letters to 20 top law firms, sort of threatening to investigate or take actions against them for DEI policies and requesting information about those policies. Is that a traditional EEOC practice?
By no means. In fact, I am part of a group of former EEOC officials that sent a letter to the acting chair in response to her letter to the law firm saying, actually, you don't have the authority to do this. And you cannot penalize these firms if they decline to respond. Fundamentally, the EEOC is a complaint-driven agency. It does not have the authority, except in very limited cases, to initiate its own investigations based on a letter from a commissioner or a curiosity about whether employers are complying with the law. An individual commissioner does have the authority to file what's called a commissioner's charge. So individuals can file charges with the EEOC or third-party organizations on their behalf. Or individual commissioners can file charges to initiate the investigative processes of the agency. But if commissioners do that, they are bound by civil and criminal penalties to keep that information confidential. So if the acting chair had in fact filed commissioner's charges against these law firms to initiate the kinds of document requests she was making, she would be liable for having violated the very strict confidentiality provisions of the law by publicizing the fact that she had sent these letters out. So I think that these were both unauthorized and onerous, and that they were being used as part of this administration's campaign to eliminate DEI initiatives, even when those initiatives are being conducted entirely lawfully and are important mechanisms to ensure compliance with Title VII and other statutes that the EEOC enforces.
Would it be your advice for the recipients of those letters, these big law firms, not to respond, not to engage, or how should they engage?
You know, obviously each law firm has to make its own calculus, and I can't provide legal advice. I would say what we were trying to do, this group of former officials, with the letter that we sent, was to ensure that the firms were aware that they had no obligation to respond and that they could not be penalized if they declined to do so. That, for example, filing a charge based exclusively on their failure to respond, or otherwise adjusting the results of investigations that were ongoing against that law firm based on their refusal to respond, would be retaliation, which is itself barred by the underlying laws. The deadline that the acting chair set for the response has already passed. She said that the law firms needed to respond by April 15th. There were public reports that 4 of the law firms that had received the letters had agreed to a settlement with the White House, which included withdrawal of the letters. But what happened with the other 16 has not been publicized, and I don't know what they've decided to do.
The other specific action I want to ask about is stopping EEOC's involvement in lawsuits investigating alleged discrimination against transgender and non-binary individuals in the workplace. First, before we get into the specifics of those cases, is it common practice for EEOC to halt involvement in litigation after a change of administration?
That has not been my experience. I don't know that it is totally unprecedented that the EEOC decided to withdraw from representation in each of the 7 pending lawsuits that were brought on behalf of trans and non-binary workers. I do think that it is notable that it is the trans status of the individuals involved and the prohibitions on gender identity discrimination that seem to have triggered the decision to file motions to withdraw. And by the way, the EEOC can't unilaterally do that. It has to be decided on by a court. I think it is heartbreaking for the individuals involved who had been relying on the EEOC to move their cases forward. I understand that all of the individuals have found counsel to step in to continue to represent them, but of course they may have to pay for that representation, and those lawyers do not have the force of the United States government behind them in trying to vindicate the rights of these people. So I would say that the costs to the individuals are substantial. But I'd also say that I think that the EEOC's position about the binary nature of sex, and by the way, I don't think the EEOC could adopt a binary definition of sex. First of all, it's not really a relevant criterion for the anti-discrimination laws, but also since they have no quorum,
Right.
they can't go ahead and say, this is our policy. But were they to try to do so when there is a new majority on the commission, I think that that would run smack up against the Supreme Court's absolutely black letter ruling that the anti-discrimination laws bar discrimination based on gender identity. And if the EEOC is refusing to enforce or bring litigation on behalf of trans or gender non-binary individuals because of its policy views that such people shouldn't exist or that they are deluded because in fact their sex is really whatever they were assigned at birth, that would be in direct contravention of their enforcement responsibilities under clear standards of law. The EEOC doesn't have to bring every meritorious case that it's confronted with. It doesn't have the resources to bring every meritorious case. But to decline to apply the Supreme Court's authoritative legal standards in its investigations and in its other enforcement work would be absolutely in contravention of the law.
Last line of questioning before we get into your lawsuit. Perhaps no employer is engaged in more public, questionably problematic content than the federal government, and thinking about the tens of thousands of federal workers who have been dismissed, then undismissed because of courts and whatnot, and obviously the EEOC plays some role in helping federal workers exercise their rights.
Right.
How, in your opinion, is the agency engaging or not engaging in what's happening right now when it comes to federal workers?
So, the EEOC's responsibilities with regard to federal workers are adjudicative in nature. So, federal workers who think that they have been subject to discrimination are obligated to go to their own agency first. So if you work for the Department of Agriculture, you go to the Department of Agriculture. If you work for the EPA, you go to the EPA. But the EEOC exists as basically a backstop. It employs administrative judges that claimants can request hearings before. It also has the capacity to review appeals from agency decisions. I think based on the recognition that would be true across the board with employers, that there needs to be a neutral entity that is making decisions about whether someone has been subject to unlawful discrimination. I don't know, since I've left, how many federal sector complaints have been filed with the agencies for which employees who've been terminated work. There would be some lag time before they came to the EEOC. So if terminated federal employees or those who've been subject to other kinds of adverse treatment, whether it's reassignment or being put on administrative leave or any other form of arguably discriminatory decision, down the road, if they are using the EEO processes to protest their treatment, I would anticipate that you'd see a spike in requests for hearings before administrative judges employed by the EEOC and or appeals to the EEOC as a decision-making process body. But I don't know how many are in the pipeline. I will say the EEO process is not the only source of protection for employees. So they can, for example, go to the Merit Systems Protection Board or to the Office of Special Counsel. And those offices have sometimes overlapping but also distinct kinds of jurisdiction that fall beyond the discrimination bases that the EEO processes are designed to address. Of course, the MSPB currently lacks a quorum because the original chair was fired by the president, as was the chair of, or one of the commissioners of the National Labor Relations Board, as
and the Office of
director
Special Counsel.
of the Office of Special Counsel. The trajectory of the NLRB and MSPB commissioners has been particularly Byzantine because they were reinstated by a district court, then removed again by a panel of an appellate court, then reinstated by the full appellate court, then removed by the Supreme Court. So they have been on and off their different agency bodies, and I can only imagine that the yo-yo effect is taking its toll both on them personally and on the work of the agencies as well.
That's such a good segue to ask about your lawsuit, but I just want to push on one thing about federal workers because it is curious to me. My sense, at least during previous administrations, is that if a private employer chose to eliminate any employee involved in leading an affinity group or an employee involved in the company's diversity, equity, and inclusion initiatives, that employee might have a pretty strong case of under anti-discrimination law that they were illegally terminated or whatnot. That is very publicly what this administration is doing throughout the federal government. So is it your understanding or belief that those such federal employees who have had their positions terminated have faced, that you mentioned, administrative leave solely because of their work on DEI, have been discriminated against in an illegal manner?
Of course, every case depends on its facts. So I can't make across-the-board pronouncements. What I can say is the law bars retaliation against employees for asserting their rights or the rights of their colleagues or third parties to be free from employment discrimination. And so to the extent that the work that these employees were doing that was labeled DEI work was in fact intended to ensure that the agency could root out discriminatory barriers and maintain an inclusive workplace in which equal opportunity was respected, I would say yes. It could well be that removing those people because of that kind of work would constitute a claim of retaliation under the law. And by the way, retaliation complaints can succeed even if the underlying complaint is found not to be meritorious. So, for example, the classic retaliation situation is someone loses out on a promotion, goes to their supervisor to say, I think you declined to promote me because I'm a woman. The supervisor then fires the person for having protested the promotion decision. Whether or not the original promotion decision was made on the basis of sex, the individual may have a valid claim of retaliation because the supervisor is prohibited from penalizing the employee for trying to protect their rights.
Let's get to your suit. You mentioned you were originally appointed by President Trump.
I was.
You received an email on the 27th indicating that you were fired.
At 10:37 p.m.
What was the reasoning given in that email?
So there were basically two sets of reasons. One was the assertion that the president had the authority to fire me at will, and that any precedent to the contrary was invalid. The second was that I had engaged in behavior that was inconsistent with my continuing to be in a policy-making position in this administration, namely support for DEI initiatives and support for Biden administration radical guidance. He also pointed to statements that I and my fellow Democratic commissioners had put out right after Inauguration Day when he issued his executive orders eliminating DEI initiatives and erasing the existence of trans people, protesting those executive orders and saying that they were contrary to law and would result in employment discrimination, and said that those demonstrated my unfitness to continue to serve. I believe that the last line of the email, I'm not sure I'm quoting it verbatim, said, "The American people deserve far better."
How did it make you feel to receive that?
I was shocked. First of all, it was 10:37 at night, and the email said that my termination would be effective as of the date of the email, so basically an hour and a half from the time that I received notification. But more broadly, I had, of course, heard rhetoric about the unitary executive theory of governance and the fact that the incoming president-elect had asserted that he had the authority to control anyone who worked for the executive branch. And there certainly had been chatter about whether he would try to terminate commissioners of independent agencies, because the EEOC is one of a dozen agencies that were created as multi-member bipartisan bodies that were intended to operate with a level of independence from the president. So I was alert to the possibility, but I guess I was naive. I thought that because I had been nominated by President Trump during his first administration and thereby determined to have been a reasonable candidate for an EEOC commissioner position, that understanding would persist throughout this administration. The other thing that surprised me was just that it was unprecedented in the history of the EEOC. Never in the 60 years of the EEOC's existence has a commissioner been terminated before the expiration of their term. But also, I had the shortest remainder of time on my term of any of the Democratic commissioners. And so I thought, it's hardly worth his time, because if he nominates someone to replace me in the winter of 2025, he just has to do it all over again when my term expires in 2026. So I would say I was surprised and I was devastated. This is work that I have committed my career to doing, that fills me with a sense of privilege and purpose. So for myself, I was deeply disappointed, and I was worried about what it signaled for the protections for vulnerable communities that the EEOC enforces.
You mentioned, I love this term, the yo-yo effect, that Hampton Dellinger and Gwen Wilcox and some of these other independent board members have experienced, of lower courts reinstating them, appellate courts taking them out, them being set back in. Certainly seems like your case might be headed in that direction. Why, as you mentioned, you didn't have a ton of time left in your term. Why pursue a case like this?
I think my complaint speaks for itself. I believe that the president's removal of me was contrary to long-standing principles of law, undermines the work of the agency and the rule of law, and I want my job back, however short my term might be.
Some of the public reporting, at least, has indicated that Mr. Dellinger chose not to pursue his claim all the way up through the full Supreme Court because of concerns about how this court might rule and the precedent that could set. How far are you willing to take this, and are you concerned that the wrong decision could further empower this unitary executive opinion?
I don't know why Mr. Dellinger decided ultimately not to pursue his complaint to the next step. Obviously, the commissioners of the NLRB and the MSPB are willing to go all the way, and there are motions pending before the Supreme Court right now in their cases. I believe, you ought to confirm this independently, that the Justice Department in those cases has asked that the Supreme Court schedule expedited argument on the merits so that they can decide during this term, which is to say by July, whether it is constitutional for Congress to protect commissioners from being fired by a president at will. I think there are also any number of other suits filed by commissioners of other agencies. So there's a suit filed by 2 commissioners of the Federal Trade Commission. There is a suit filed by, I think, 2 commissioners of the Privacy and Civil Liberties Oversight Board, I think is what it is.
More word
like
salad.
Right. PCLOB, I think, is what it's called. And those are all pending before different judges in the courts. So I think that this is an issue that is being presented across the board in these lawsuits, and we'll have to wait to see what the Supreme Court's appetite is to take it up.
Last questions. What's your message to American workers who might, particularly minority workers, LGBT people, women, who might be seeing what's happening and be worried about their safety at work?
Yeah, I mean, I find what has been happening over the course of the last 4 months to be heartbreaking and wrenching and so damaging to vulnerable communities. I want people to know they have a lot of support, and that whether it is former officials of the enforcement agencies who are prepared to speak out on behalf of the rights of these vulnerable communities, or nonprofit groups that are all about supporting stakeholders who are subject to attack or deprivation as a result of the things this administration is doing, or members of their communities themselves. We need to band together to uphold the basic principles that make this country great. And progress is never linear. It is always a process of forward motion and backlash and forward motion. And I do have confidence that over time, I didn't make up this quote, the arc of the moral universe is long, but it will bend toward justice. And I think finding sources of resilience and comfort and refusing to accept the erosion of basic rights and legal principles is what's going to sustain us through this period.
Thank you so much for speaking with me and sharing all these thoughts.
Thank you so much for chatting with me. It's been a pleasure.
Anything I didn't ask you about